Okay, great. So, thank you everyone, and thank you Anya and the rest of the team at the new school for having me and allowing me to do this presentation for the students. This is post-graduation immigration options. My name is Lauren Joe. I'm an attorney. I have my own firm, Lauren Joe Law. I'm located in New York City in Brooklyn. I actually have a virtual office, which everyone these days I guess is virtual, but I don't have an office space, but I do Zoom and phone consultations and everything, and I could come to you if that's needed as well. And I can assist anyone across the country. So not only in New York City, but immigration law is a special category since it's federal law. I'm not restricted to only helping individuals in New York State where I am a licensed attorney. So, okay, so just a little bit about me. I'm Lauren Joe. I've worked in the immigration law field for over a decade. I actually started out as a paralegal and now an attorney. I was sworn in to the New York Bar in 2015 after I graduated law school. So when I started as a paralegal, I started actually in immigration law, and that's kind of how I fell into it. I didn't know one thing about immigration law, what USCIS was, what an H-1B was on my first day, and it was very on-the-job training, but I've learned a ton over the past 10 years, and I'm still learning new things every day as the laws change every day, as we kind of saw from yesterday and last night and today. Even like things are still changing literally every day in immigration, so that's why it's really important to work with an attorney on your case, because sometimes you might not even know that something has changed in the process of your application. So I worked previously, before I started my own firm, I worked for Fragaman, Del Rey, Bernstein and Lowy. It's a large law firm that practices only immigration law. We had 600 attorneys worldwide, with its main headquarters in Manhattan here. And I've worked with thousands of foreign nationals over the last decade on their work visas and green card applications. So I've kind of covered it all in terms of business immigration and green cards and naturalization and things like that. And just personally, I live in Brooklyn with my husband, Andrew, and my cat, Yogi. So just kind of what we'll be going over today. Just an overview, I call it the alphabet soup of immigration. This is a lot of the non-immigrant based visas, since they're all kind of based on letters, so like a B1, F1, H1B visas, along with the employment-based immigrant visa, so green cards. We'll go over all the non-immigrant visa options that are temporary employment-based visas. So I'm not covering every single one, but kind of just the ones that I think would be most pertinent to students graduating. And if you do have additional questions about something that I didn't cover, you can ask either questions at the end, or if you have individual questions, feel free to shoot me an email. I'll have my contact information on the last slide. And then we'll cover green cards, that's immigrant visa options, kind of the language that the Immigration Service uses is non-immigrant for temporary visas, and you're only considered an immigrant if you're intending to come here permanently on a green card. And then I'll cover some immigration updates. There have been numerous immigration updates in the last 24 hours with a new Biden administration. And there have also been tons of changes over the last 4 years. Some of them are still implemented, and especially over the last year with COVID restrictions as well on immigration and travel. So just to start off, I have this quote that I have actually on my website as well from former President Barack Obama. Being an American is not just blood or birth, but an allegiance to our founding principles and the faith in the idea that anyone from anywhere can write the next great chapter of our story. And I always just kind of like to start with that quote. It's a little bit of an inspirational quote, but it really kind of encaptures not only the Obama administration's attitude on immigration, but that's also kind of the Biden administration, so now incoming administration's view on immigration, which is promising for all of you. And for me, it's been quite a frustrating last 4 years with a lot of roadblocks, and I'm looking forward to a little bit smoother path and a little bit more pro-immigrant rhetoric over the next 4 years. So the overview of the immigration categories. So like I said, there's non-immigrant, which are temporary visas. Some of them have a set time frame, a maximum time frame, and some of them you have to keep renewing, and some of them can be renewed technically indefinitely. You could keep renewing every 3 years as long as you still qualify, but it's still a temporary visa. And then immigrant category is the green card category, which I'm going to go over the employment-based green card categories and just kind of briefly touch on family-based, really just spousal-based, which is another option if you don't have a non-immigrant visa or a company that will petition for a green card for you. If you happen to have a US citizen or a green card holding spouse, that's always an option as well, and maybe even a better option. And then citizenship, I won't touch today, but that's just kind of the last stage. Typically, someone goes from non-immigrant temporary visa holder to green card holder, and then 3 or 5 years later, they're eligible to apply for their naturalization citizenship. And I'll cover questions at the end. So if any of you have questions, put them in the chat box, or at the end, I'll just kind of call out and you can unmute yourself and ask some questions. Okay. Okay, so F1 student visa and optional practical training. So I'm guessing that a lot of you are probably on F1 student visas right now in the US, or actually I've heard, Anya told me that some of you are actually maybe outside the US right now due to some of the COVID-19 travel restrictions and virtual school and everything. It's a little bit of a weird time. But generally, if you're in the US on an F1 student visa, there's post-completion optional practical training, OPT for short. And what this is after you graduate, you get, well, there's pre-completion OPT. I'm just gonna cover the post-completion OPT. So this is post-graduation. You're eligible for a temporary employment work card. That's the employment has to be directly related to your area of study. So if you're engineering major, say, just as an example, you can't really take a job in like at an art gallery or something, so to speak, or vice versa. It has to be related to your major. And then eligible students can apply to get 12 months of OPT employment authorization after graduation. So what you would do is you work with the International Student Office, the DSO, and they'll help you apply for this OPT. They'll authorize it on your I-20 form, and then you would apply with USCIS for the EAD card, employment authorization document, and that would be valid for 1 year. If you are in a STEM major, so that's science, technology, engineering, or math, and the government has a list of qualified STEM fields, and that field is listed on your I-20, so there's a little number for your major and whether it qualifies for the STEM field. And if you have this, then you qualify for an extra 24-month extension of OPT. So you would actually get 3 years of this work authorization, which is great. And it really comes in handy with if you're applying for an H-1B, which I'll get to. But some of the qualifications for the STEM OPT, one, you have to have the STEM major. The employer must be an E-Verify employer. And if they're not, they can apply to become an E-Verify employer. It's not really that difficult, but most employers are, or if they're a large company, they most likely are. And then you have to complete a detailed training plan, which is the form I-983, with your employer. So since this is optional practical training, it's still considered training, and you're working with your employer on a specific training plan. They have goals and milestones for you to hit, and they also have to check in every now and then and do little reviews of whether you are meeting those goals. So you work on this with your employer and you provide it to the DSO at school, and then you can apply for another EAD card with USCIS. That's the 2-year extra EAD. And like I said, with this comes in handy with the H-1B because it allows multiple entries into the H-1B lottery over that 3-year period of the first OPT and then the 2 years of STEM OPT. And I'll get to the H-1B lottery. Okay. Okay, so the H-1B specialty occupation visa, this is kind of the bread and butter of the non-immigrant work visas. And I'm sure a lot of you have heard about the H-1B. It's sometimes in the news, for better or for worse. Some people are against it, a lot of people are for it. I'm very pro H-1B. I think it's a great visa category if you can get it. That's kind of the issue with it, at least for applicants. So some of the requirements are the position that you're being sponsored for the H-1B. The job must require at least a bachelor's degree or equivalent in a specific field as the minimum entry level requirement. So it's a little bit tricky and sometimes has to be kind of argued to the government if they request more information. But not only does the actual position that you are applying for, so you say you apply for a job, you look at the job posting on LinkedIn or something, and it says requires a bachelor's degree and 2 years of experience and XYZ skills. If that company happens to be requiring a bachelor's degree for a role that typically doesn't require a bachelor's degree, so say it's just for an example of a position that normally doesn't require a bachelor's degree, might be like a receptionist role or something. But if some company says, hey, we want all our receptionists to have bachelor's degrees, that probably won't fly with USCIS because it has to be a role that typically requires a bachelor's degree. And they kind of look at everything as a whole, kind of across the labor market. And then, so not only does the job have to qualify as a specialty occupation, you must qualify and have a degree equivalent to a US bachelor's or equivalent experience in the job field. So either a US bachelor's or equivalent. So if you have a foreign bachelor's degree, there are companies that do equivalency evaluation. So we would send your degree off to that company, and they have people that look at all the requirements for those foreign degrees, and they say, okay, yes, this bachelor's of engineering from India is equivalent to a US bachelor's of science in engineering. And then you get that and you would submit that with your application. And also job experience to qualify as equivalent to a bachelor's degree. USCIS uses a rule of 3 years of experience for every 1 year of university experience. So if you don't have any sort of bachelor's degree and you want to qualify for an H-1B, you have to have at least 12 years of experience in the field that you're trying to qualify for. That would be equivalent to the major. And then lastly, the employer must pay at least the prevailing wage for the occupation in the geographic area. So what this is the prevailing wage is basically a minimum wage for an H-1B, and it's meant to protect H-1B workers in the field. So it's changes based on the occupational category. So a lawyer prevailing wage isn't going to be the same as an engineer. And a lawyer in New York City, the salary isn't going to be the same as a lawyer in Kansas because it's a different cost of living. Sorry. So the government has a list of prevailing wages. It's basically a big library of prevailing wages. So you would look up your the category of your occupation, the position that's being sponsored, and the geographic area where the job will take place, where you will physically work. So even if the company is located in New York, but if you're physically sitting in Atlanta because you're working from home, it would be out of Atlanta, which could maybe benefit you because the prevailing wage might be a lot lower in Atlanta than it would be in New York City for the same position. And the way that the prevailing wage is kind of documented, so the H-1B petition is really kind of two steps, the actual petition. I'll get to the lottery in a second. That's a whole kind of preliminary step before you're even able to actually file the petition. So the application process here on the right, I have the lottery selection process, which I'll just get to in a second, determining the prevailing wage. So like I said, you go on the online database of prevailing wages and find out what the prevailing wage is for your job and for your level. It goes from 1 to 4, 1 being entry level and 4 being the highest level for that position. Typically, if you're coming out of school, it would be probably a level 1 or 2. And your employer must pay you at least that wage. If the salary happens to be higher, that's fine. Then you meet the prevailing wage and there's no issue. The company must draft a labor condition application, so an LCA, with the Department of Labor. So this is not with the Immigration Service, this is with the Department of Labor in conjunction with the H-1B application. And it's basically a form saying this company wants to hire an H-1B worker for this job title at this address. We're willing to pay this salary. This is what the prevailing wage is. That form must be posted publicly at the company. So all employees of that company are aware. So if you've ever worked in an office, sometimes you see, like in the break room, there's government postings about PTO and time off and things like, and benefits and things like that. So that's usually where it would be posted. So if you've ever seen one of these posted on the wall, so it could be physically posted at the work location. Right now, that's a little tricky because of COVID, where a lot of offices are not using their office and everyone's working from home, but the LCA is meant to notify and all the employees at the company. So how do they do that if you don't go into the office? If the company has an intranet for their employees, for example, then they might post the notices there. It doesn't have your name on it, but it does have the job title and the salary. They must post that for 10 days. And then once it's posted and the employer confirms that it's been posted either online on their intranet that everyone has access to, or the in-person office, or if you're at home, say you work from home by yourself, it sounds silly, but you're supposed to post it at the workplace, which might just be posted on your fridge or a bulletin board in your home office. So I've always found that a little ridiculous, but if you want to follow the rules, you have to post it in the workplace so everyone there knows, so your dog and cat will know what you're making and making the prevailing wage. And then after that's done, you file the company will file the LCA with the Department of Labor. And then once that's certified in about a week, the final version will be inserted into the H-1B petition that goes to USCIS. So that's step 4, is the I-129 petition with USCIS. These are the government immigration forms. A lot of it is biographic information, a support letter from the company explaining what the position is, how it qualifies as a specialty occupation, who you are, your degree qualification, and basically proving that you do qualify for that position. And then all the documents like your passport, your degree, your I-20 forms, your copy of your visa, EAD card, et cetera, things like that, and documentation about the company. And then the certified LCA, that all gets sent to USCIS. And then just the last point, the petition can be filed, I mean, it always has to be filed with USCIS, but you can file it as a change of status if you are in the US in a valid status. So say you're an F1 student and you're working on OPT, you can file it in a way so you can change automatically into H-1B status, which would start October 1st, the start of the fiscal year, the government's fiscal year. Or if you want to stay in your F1 status for a little bit longer, say you get picked in the lottery and you have STEM OPT, so you could, or you'll be eligible for STEM OPT, so you could possibly have 3 years of OPT that you want to use before you kind of activate your H-1B. You can get it so it's consular notification, so you can travel at a later date and get your H-1B visa stamped at a US consulate abroad. I don't recommend this right now since travel is iffy, consulates are closed or operating extremely slowly. So I wouldn't recommend this as an option, especially if your visa expires this year. Excuse me. Okay, so this is an example of the prevailing wages that I was talking about. So this example is for a graphic designer in the New York metro area. So online, on the online website, level 1 entry level, the government says that the prevailing wage is $42,432 a year. So an entry level position in New York City, your employer just has to pay you over $42,432 if it is an entry level position. If it's higher, then level 2, 3, 4 for very experienced. And then this would change based on the location. Okay, so the lottery. So I talked about how the petition is actually put together with the LCA, I-129 form, documents, what's required, how to qualify for an H-1B. But the sticky part about the H-1B is that there is a quota of H-1B visas per year. So there's 65,000 new H-1Bs available per fiscal year for bachelor's degree holder or equivalent, so either experience or a bachelor's degree. And then 20,000 H-1Bs per fiscal year for US master's degree holders. So this is only US master's degree. If you have a foreign master's degree, then that you would only count towards the 65,000 bachelor's degrees. So it works out if you're a US master's degree holder, you kind of get 2 bites at the apple because they run 2 separate lotteries for these these different quota groups. So if you're a US master's degree holder, you automatically have a bachelor's degree as well. So you would get thrown into that 65,000 person lottery. And then if you don't get selected in that, you also go into the 20,000 person lottery as well. So a little bit bonus there. And you must have the master's degree by the time that you file the application. So the the timing for the lottery, which changed a little bit last year. Sorry. So just a little bit of history with the H-1B. Everyone used to just file their petition on October 1st or on April 1st every year and hope you get selected. And if you get selected, they process. And if they don't select you, then your petition would just get returned to you. Last year, they started an online registration system, which is, in my opinion, maybe one of the only good things that the Trump administration did in immigration, was it really streamlined the process and really helped small businesses file for H-1Bs as well, because a lot of the H-1B lottery system is dominated by large tech companies, which, because they have the resources to file thousands of applications, so there's only 85,000 available per year. In the last several years, there have been 200,000 or more applications each year, including through the online registration system. But for a small company that might only have the money to file for one or two of their employees, it's a little bit harder to justify paying that money when there's no guarantee on the return of their employee being selected. There's no guarantee of their employee getting the visa and starting work. So some companies, especially small companies, don't want to pay that. Whereas big companies like the IBMs of the world file thousands and thousands of H-1B applications each year. But the online registration system is just a short form of basically biographic information that's filed between March 1st and March 20th. Those were the dates last year. USCIS has not announced that those will be the exact same dates this year, but likely will be, but there's no confirmation yet. So I don't want to say definitely. But the employer and the lawyer will both have online portals into this USCIS system where you complete the registration, basic information. There's only a $10 filing fee per registration, rather than the thousands of dollars of USCIS filing fees for a full application. And then if you're selected in the lottery, so they announced the lottery results between March 20th and March 31st. And then if you're selected, you'll see in the online portal, it'll say selected. You can then go ahead and file that petition with USCIS within 90 days. So the timetable for the H-1B, this is if you're selected and then you file your petition. If it's with regular processing, is usually, this is highly variable, but 2 to 6 months processing. USCIS sometimes removes their premium processing option for H-1B cap petitions, or they delay it. Last year, I think it was June that they started upgrading to premium processing. And then cap gap. So this is something that the F1 students should pay attention to. Cap gap is, so if you are in the end of your OPT, so say your OPT EAD card expires June 30th, and you get selected in the H-1B lottery in March, you go ahead and file your petition in April. But the first day that an H-1B can start is October 1st, because that's the start of the fiscal year. That's when all H-1Bs, the earliest date they can, you can start in that status. So if you do a change of status, you would automatically flip over from F1 to H-1B on October 1st. If you happen to be in the situation where your EAD expires between the time that you file the H-1B petition and October 1st, as long as you're in valid OPT status, not CPT, you get a cap gap extension. So your work authorization would be extended from that June 30th EAD expiration date to October 1st, and you have to work with the DSO and the International Students Office to get that notation on your I-20. And then you don't have to apply for a new EAD card because you would have that notation on your I-20. And then you can just continue working until October 1st. And this is only if you file as the change of status, where you would flip over to H-1B on October 1st. If you filed in the consular notification manner, where you would go and get the visa at a U.S. consulate, you're not eligible for CAP-GAP. So it's kind of really important to determine whether you qualify for that. And if you do, don't file for consular. Otherwise, you would be stuck without work authorization from the date of your EAD card until, or not even October 1st, until you can get the H-1B visa stamp in your passport. And then premium processing, which I mentioned, that's an additional fee to the government. It's a $2,500 government filing fee that the petitioner employer would pay to process the application within 15 calendar days. And like I said, that's not always available for H-1B CAP. Usually it's just delayed. In processing the application within 15 days, this really means that USCIS will provide an answer within 15 days. It doesn't mean that they'll ultimately decide your case. Sometimes they'll issue a request for evidence, RFE, on your case within 15 days that you have about 3 months to respond to and give more information about why you or the position qualifies as an H-1B. And this could delay the process 2 to 3 months. Sometimes there's a lot of documentation or legal analysis that's required in responding to an H-1B RFE. So the duration of the H-1B visa is 3 years, up to 3 years for the first grant. So if you apply in the lottery, the max time you can get status is 3 years, and it's renewable for up to 6 years. So there's one initial application and then typically one more to get you to the 6-year max out. So it can only be extended beyond 6 years in special circumstances. If you're waiting for a green card, you already have a green card application in it, but there are long wait times for your home country, or you have PERM, which we'll get into a little bit later, which is a type of green card application pending more than 1 year before your H-6-year mark. The costs of the H-1B are, these are all the government filing fees, $460 base fee, $500 anti-fraud fee, and then either a $1,500 or $750 this education fee, and it changes depending on how large the company is, and then $2,500 if you opt for premium processing, but that's not required. But it is not cheap for the company to file the H-1B requiring all these fees, and that's why I think the online registration process that only cost $10 was a good implementation last year. So if you don't get selected in the lottery, it only costs $10. You only lost $10, or the company did. I had this slide in, and then as of yesterday, around 10 o'clock, they put this on hold. So the Biden administration put basically all regulatory rules that have been introduced by the Trump administration within the last 60 days on hold for a review. This was one that was just finalized on January 8th. About replacing the random H-1B lottery with selection based on wage level. So what this is doing, it's prioritizing higher salary positions in that DOL wage level. So you saw this 4 different wage levels, with one being the lowest. USCIS would be, instead of just randomizing and picking random H-1B registrations, they would be allocating them with priority to the higher salary levels. So this has been put on hold for now. I can't say whether or not it will be on hold forever, but as of now, for this year, this is something you shouldn't have to worry about. So I'll just kind of skip over this, but I just wanted to let you know, in case you had heard about that in the news. That's one thing that just late last night they said they're putting on hold. So that was the H-1B lottery, the quota, they call it the cap quota. And then there's also H-1Bs that are cap exempt, meaning you don't have to enter that lottery and you can basically apply anytime throughout the year, but your company has to qualify for this. So the H-1B employers that are not subject to the quota are institutions of higher education, nonprofit entities which are related to or affiliated with institutions of higher education, nonprofit research organizations, and government research organizations. So if you are offered a position by one of these types of companies, it's actually, I would say it's a benefit. You don't have to enter the lottery. Although if you say you got an H-1B, cap exempt H-1B from one of these companies and you work there for a couple of years and then you get a job offer from a for-profit company, you can't just switch to that other for-profit company with your existing H-1B because you haven't been counted against the cap quota. So you would have to be entered into the lottery again. But you can switch to other cap exempt companies. So if you work for one university and you want to switch to another, or a nonprofit or a government research organization, you can do that. But you can't then switch. You can't get around the cap by going to a for-profit company from a nonprofit cap exempt company. So that was H-1Bs. That's kind of the heavy lifting for the non-immigrant categories. The next visa I'll talk about is the TN visa. So this is only available for Canadian or Mexican citizens. It's a little bit similar to an H-1B in that it's for professionals. So it was this is under the former NAFTA treaty, now USMCA, United States, Mexico, Canada agreement. So it's a treaty-based visa category. And in that treaty, they have a list of professions that would qualify for the TN visa. So most of them require bachelor's degrees. Some of them require certain licenses. So like, for example, a lawyer is one of the positions on it. You obviously have to have the correct education, but you also have to be licensed to practice law. You can't just have a JD. You have to pass the bar and be licensed in the state that you'll be working in. So if you look on the list, you can find out what the education requirement for that profession is. Oops. Okay. And then you also have to have an employer sponsor willing to hire you full or part-time for that position. So all of these visa categories, really you need, almost all of them, you need an employer sponsor because they are the one actually filing the petition with USCIS saying, we want to hire this foreign national individual and sponsor them for this visa. There's not a ton of categories where you can self-petition for yourself, but we'll get to one category where you can actually do that. The application process for the TN is a lot easier than the H-1B. There's no prevailing wage, there's no labor condition application, LCA. It differs depending on if you're Canadian or Mexican. So Canadians are visa exempt, meaning they don't have to get the actual visa stamp in their passport. They still have to be approved for the TN status and category, but they can go to the port of entry either at a major airport in Canada or to the actual land border, and apply for the visa with the officer there. So if you've ever been to like the Montreal or the Toronto airport, you actually go, when you're coming to the US, you actually go through US immigration on the Canadian side. It's a little weird, but they have US immigration officers in Canada at those airports. So you technically pass through into the US, not border-wise, but at least immigration-wise, before you even get on the plane. So that's where you would process a TN if you're Canadian. And then if you're Mexican, you do require the visa stamp in your passport, and you can apply directly at a US consulate in Mexico and present the TN application. Or you could petition with USCIS if you're already in the US. So if you're in F1 status and you want to do a change of status from F1 to TN, you can file with USCIS. Normally, I don't recommend this because USCIS has always been more of a pain to get applications approved rather than a consulate or a port of entry. But since travel right now is not ideal, if you can't or won't travel, you can file your petition with USCIS, and you can file premium processing for this with that extra fee as well. I know travel to Mexico right now is a little easier than a lot of other places in the world, so it is possible, and certain consulates in Mexico are processing TN applications, but getting an appointment at US consulates right now is quite a nightmare. So this is maybe the one time due to COVID that I would recommend that you actually apply with USCIS. And maybe with the Biden administration, the USCIS processing might get a little bit easier. So what's required in the application, you have to have a support letter from your employer detailing the role and the qualifications of the applicant. So it's pretty simple. It's a letter from the employing company saying, we want to hire so-and-so for this job. Here's a description of the job. It requires a bachelor's degree in XYZ. We want this person that we want to sponsor. They have a bachelor's degree in XYZ. It matches, it's perfect. And then it would be a copy of your passport. If you're already in the US in another status, your I-94, your I-20, other qualifying status documents, and then your educational documents, and then information about the company. So it's a lot more simple application than the H-1B. And usually, as long as you have the qualifying degree and it's not too much of a stretch on your degree being related to the job, it would likely be approved. I haven't had too many issues with TNs. And then another category that's also country nationality specific, H-1B1 and E3 specialty occupations. So the base requirements for these visa categories are pretty much identical to the H-1B that we talked about, where it has to be a specialty occupation role that requires a minimum of a bachelor's degree in a specific field, and you hold that, that degree in that related field. And you do the prevailing wage, the LCA with the Department of Labor, that whole thing. E3s are for Australian citizens only. And H-1B1s are for Singaporean or Chilean citizens only. So these are very specific. If you're not from any of these countries, then these are irrelevant to you, but it's pretty much an H-1B without the lottery. And you can also apply at the consulate. So the application process, you, same as the H-1B, determine the prevailing wage, post the LCA, and file with Department of Labor. And you can either file with the USCIS or you can apply directly at a US consulate abroad. For E3s, typically people file in Australia, and those consulates are very familiar with E3s. But if you don't want to go all the way to Australia, or you can't get to Australia due to travel restrictions. A lot of other consulates around the world, especially Mexico and in the Caribbean, process E3s as well. They're pretty familiar with Australians that don't want to hop on a 24-hour flight to go back home. So these visas are valid for up to 3 years at a time, just like the H-1B, but there is no 6-year maximum validity like the H-1B. So if you're Australian and you can get an E3, you can keep on renewing for as long as you still qualify and as long as your job still qualifies. There are a couple things to keep in mind. So I have special issues with H-1B1 and E3. There's no dual intent with these visas. Dual intent means, so non-immigrant visas, you're coming with the intent that it's a temporary stay. You're not intending to file for a green card or immigrate to the US permanently, so file for a green card. Some non-immigrant visa categories, even though they're non-immigrant and temporary, like the H-1B, just the regular H-1B, has dual intent, and they say it's okay if you file for a green card while you're on an H-1B, totally allowed. So the H-1B and the L visa, which I'm not going to cover today, allow that dual intent. The E3 does not. So there can be some tricky situations with the E3 or H-1B or TN. So TN is also not a dual intent visa, but it can be done. But I would recommend definitely working with a lawyer if you're in one of those statuses and filing for a green card or intending to file for a green card, whether it's employment-based or family. Okay, so the other consideration with the E3 visa is it allows spouses to apply for a work card, which the H-1B does not, unless you're in that post 6-year period waiting for your green card, then your H-4 spouse can apply for a work card. But E3s, if you're married and your spouse does not have their own independent work authorization, they can apply for an EAD card through your E3 status. So that's a very big benefit of E3. H-1B1 does not have that. Okay, so J1, let me just check the time. I'm kind of behind. Okay, J1 visas, I'll just cover briefly. There's several different categories that you see on the left. Probably the most used would be the trainee and intern categories, which are pretty short relatively to other visas, 12 months or 18 months. And so these are short-term training visas that are done through the Department of State, where the employer uses a third-party sponsor agency. Not many individuals are probably going from F1 to J1 unless they're going into like a PhD program for the professor research scholar. And some of the special issues with the J1 to be careful about are a 2-year home residency requirement. So some participants are required to go back to their home country after their visa program is over. You have to go back to your home country, not a third-party country, wherever you want, and stay there for 2 years because kind of the purpose of the visa was to bring the cultural exchange of ideas back to your country. So one of the requirements for home residency is if your country has a particular skill that's lacking in that country, you come and train in the US in that skill, and then you're meant to come back to your home country to bring that knowledge back. And that's the purpose of the visa. And if you stay for 2 years, then you're free to come back. You can apply for an H-1B or green card or other type of visas if you qualify. You can get a waiver sometimes of these home residency requirements. Sometimes a waiver is never issued. Like if you're a Fulbright scholar, it's pretty impossible, I'll say impossible, to get a waiver for that type of home residency requirement. My sister-in-law actually was a Fulbright scholar in the US from Costa Rica, and she, she had to go back to Costa Rica for 2 years. And well, more than 2 years she's been there, but my brother followed her to Costa Rica and now he lives there. Not the worst place to live, I guess. Okay, the O1 Extraordinary Ability Visa, this is a category that, so I mentioned before, there aren't many categories that allow self-petitioning, where you don't have to have an employer. This is one that does allow that, or you can petition with like an agent. So a lot of individuals who are in the arts are file O1s because you might not have the typical employer-employee type of job. You might be a freelancer. You might be doing different, like I've done O1s for Broadway dancers or things like that, singers, where they might have a job for a gig for 6 months and then they have another gig lined up in the fall and then something next spring. So there's like a lot of different jobs. They don't have one employer that they plan on working for the next 3 years. So it works a little better with that type of job. So these are individuals with extraordinary ability, which is a pretty high bar for USCIS. O1A category is for science, education, business, or athletics. And then O1B is arts or motion picture, television industry. So what's required for this petition? So basically they define extraordinary as being the very top of your field. Not just, I mean, you might be extraordinary. I might think you're extraordinary, but if you can't document it and back it up with letters of support, testimonials from other people in the field. So if other experts in the field or well-known people in that field say, hey, I know John Smith and he's really good at this, and I should know because I'm an expert. So if you get a bunch of testimonials, publications and major trade publications, a lot of time they want to see international acclaim. So not only just like the school newspaper type thing, but more of like, were you in the New York Times or other international publications or publications in that that industry, so industry publications. A high salary for the field, media citations if it's a academic position. So if it's in science, say your extraordinary ability in chemistry. If you write lots of academic papers and they've been cited by hundreds of other people, then that's a big deal. If you judge others' work, so if you're on a panel that awards other people awards, then that's one thing to qualify. You have received awards yourself and critical acclaim, member of selective professional memberships, not just anything that you can join, but you can only join if you're really good. And then employment in critical or essential capacity for organizations with a distinguished reputation. So you don't have to meet all of these, but you have to meet at least 3. So these are kind of the option categories that you can choose from and pick and choose. Like you might have lots of letters of support, a very high salary, and employment in a critical or essential capacity. As long as, and you could definitely meet more than 3, but you have to meet at least 3. And you can also have an employer file this as well, certainly, but it's just one that you're not required. Okay, DACA. So DACA has been restored. If you are in a DACA status, right now, you can continue to extend your status and extend your EAD card in 2-year increments. If you have not been in DACA, you can now file an initial application, which as of a couple of years ago was suspended by the Trump administration, but as of December of last year, it's been re-implemented. You can file new applications, a work card for 2-year increments. And you can also apply for a travel card, which hasn't been allowed for a while. And then also one of the policies proposed by the Biden administration yesterday, he sent over proposed legislation to provide green cards for present DACA holders so that they would be eligible to immediately apply for a green card. So that's just a proposal to Congress now. It'd be a long time until that becomes a law if it gets passed, but that's just something that's in the works as of yesterday. Okay, so I'm kind of running out of time, or I'll cut into our Q&A. But so we covered all of the non-immigrant, or most of the non-immigrant category. I didn't go over every single type of visa there, but I covered the ones that would be most relevant. And then I want to move on to immigrant. So covered non-immigrant visa, temporary visas. Immigrant, like I said, is green card based. So employment based, I'm only going to cover the employment based, not the family based. But the government categorizes employment based green cards in different preference levels. So EB means employment based, preference level 1, 2, 3, 4, 5. There's a couple subcategories: extraordinary ability, which is very similar to the O1 that we just talked about. Outstanding researcher, which is a little bit similar to extraordinary ability, but in the research field. And then multinational manager, which probably wouldn't apply to students in the US, but that's someone who worked for a company outside the US as manager or executive, and then is transferred to a related company, like the US office of that company, as a manager. And then the most relevant categories are probably EB2 and EB3. EB2 is for advanced degree holders or national interest waiver applications. And then EB3 is professionals, skilled, or other workers. EB3 would be bachelor's degree holders. And then EB4 is special category, like VAWA and religious individuals. And then EB5 is investor, which you have to invest. I think the limit now is like $1.8 million into a US business, and then a lot of requirements, but then get a green card. Okay. So just a very high level overview of the steps of the green card process. There's about 1 million little steps between these, but just the very basics. If you're going through the green card process with an employer, which I'll just note can be done, you can be an F1 student and say you're working somewhere on pre-completion OPT, and the company wants to hire you after graduation, and then you get employed on OPT. They can start the green card process for you even while you're on an F1. A lot of companies don't do it until you're in like H-1B or E3 status or another non-immigrant status, and they delay it a little while because they want to make sure if someone's a good fit for the company or something before they invest in that money and time in the process. But it can be done from F1. So the PERM labor certification process, most employment-based green cards start here. This process alone takes approximately 1 year, and it's all done with the Department of Labor. So you don't even get to the Immigration Service until step 2. But I'll go over a little bit more detail on the PERM labor certification process in a minute. So after you finish the PERM process with the Department of Labor, the company will file an I-140 petition. That's an employment-based green card petition for the beneficiary or the employee. And then if you're doing family-based, like through a spouse, they would file an I-130 application, and you would not have the PERM process. And then the processing for that is about 5 to 14 months right now. And the government processing times change all the time. Right now, they're pretty long because they're short-staffed at USCIS. And then step 3, so step 3 is split into 2 different sections there. Adjustment of status, the I-485 application, or consular processing. So the I-485 is if visa numbers are available, which I'll get to explaining that in a minute, and you're presently in the US. So if you're working for a company in H-1B status and the company goes through the PERM process for you, and it's time to, you get your PERM certified, it's time to file the I-140. You can sometimes file the I-485 adjustment of status, that's the 3rd step of the green card process, together with the I-140, depending on your category and your country of birth. So that's what if visa numbers available means. And then you can also do it through consular processing, either if you're already outside the US, say you're not even working for the company yet and you're living abroad, you can do it where you can apply for the immigrant visa at the consulate, or you can do this later down the road as well if you're in a non-immigrant status in the US, and just when the time comes, you'll go to the consulate. And then after that, either the I-485 or the consular processing is approved, green card issued. It seems like a very simple process from this little infographic, but it's not that simple. So the PERM process, a basic overview is the reason that this process exists. So it's called a labor market test, and the government wants to ensure protection for the US economy and US workers. So they have to determine before a green card is issued, which is a pretty large benefit. It's basically the highest, biggest benefit, immigration benefit that you can get other than before you become a US citizen. So before they issue that to a foreign worker, they want to make sure that there are not any minimally qualified US workers, that means US citizens or green card holders, for the job offered in the green card application. So this is for the EB2 and EB3 category. EB2 is for advanced degree, and this is if the job requires an advanced degree, and obviously you have to qualify for the job. But if the job requires a master's degree or a bachelor's plus 5 years of progressive experience, it counts as EB2. If there's a bachelor's or equivalent, that's EB3 professional, skilled worker, 2 years of experience, or unskilled category, that's EB3. And there's 3 stages to the labor market test. So the first one is the prevailing wage request to the Department of Labor. So this is very similar to the prevailing wage from back with the H-1B that we were talking about, except through the PERM process, the government determines the prevailing wage for you in your job category. With the H-1B, they trust employers enough to pick the category that best fits the job. With PERM, you give the Department of Labor the job description and the requirements for the position. Say these are all the tasks that somebody will perform. It requires a bachelor's degree in engineering and 2 years of experience in these tools or software. And then the government will come back 4 to 6 months later, they're pretty slow at this right now, and say, okay, we think this job falls into the software developer category at a level 2, so the prevailing wage is X. And you can challenge that if you don't think it's the right category or you think the wage level is too high. And sometimes they'll change it, but sometimes they'll come back and say, no, we think this is right. So the government or the employer would either have to pay that prevailing wage, which might be higher than they originally intended, or stop the application if they can't pay that or not willing to. If they are willing to, then they go through the recruitment process. And the recruitment, this is actual job postings for about 3 months There's a whole list of required manner of posting. They have to post in Sunday newspapers, which who looks for a job in the newspaper anymore, but this is what's in the regulations. So if you ever pick up a Sunday New York Times and you go to the classified section, you'll see a ton of job listings for a lot of software developer positions and H-1B type roles. And these are the perm ads. So the company has to pay for these advertisements with the job listing to see in this area. So say it's in New York City, you have to advertise in New York City and see if there is any US workers who actually apply for the job and are qualified. And if someone applies who is qualified and a US citizen or green card holder, then the green card application cannot move on. It has to stop. There's no actual job unless they really want to hire that person, but the poor person applying for this position that doesn't really exist is probably not going to get that job, but it also means that the green card application cannot move forward. If there are no qualified applicants, and this is minimally qualified, it doesn't have to be someone extraordinary for the job, it's just, do they have the base degree and experience for the role? And if they do, then the application is over. And it can be restarted after a 6-month waiting period. But say there's no one qualified for the job. Then you would file the labor certification application to the Department of Labor. This is kind of a, this is just the last step in the application that goes over the job, all the requirements, your past experience, and then in about 6 months, that would be approved as well. So as you can see, the perm labor certification process takes a long time, and there are lots of bumps in the process that if you hit one of those bumps, it could get derailed. So I always recommend to employers that they start the perm process early on if they are intending to file for a green card for an employee, especially in the H-1B, for someone in H-1B status, because there is that 6-year maximum period in H-1B. You want to get it done sooner rather than later if you are going to go through this process, because it's so long. And if you run up against that 6 years, then unfortunately the employee would have to go off payroll or get in another status if that's possible. It could be a mess. So green card quotas and priority dates. So just like the H-1B, there are quotas. The government allows 140,000 employment-based and 226,000 family-based green cards per year. So no country is permitted more than 7%. It's a weird kind of formula that the government uses. Nobody actually knows exactly kind of how this formula works. But because it's basically a per country quota system, there are countries with higher demand. There's more people from certain countries just based on population that want to come to the US, which creates long backlogs. So I'm sure if you're from one of these countries like China, India, sometimes Mexico and the Philippines, but almost always China and India have these long green card backlogs that prevent them from getting a green card immediately. So they can't file that third stage of the green card process. We talked about the I-485 or the consular processing. They have to wait until a visa becomes available. So they get put in that backlog. They're in line. You get your priority date when you filed the perm application. So that's kind of your place in line. And then I'll show you what these are the numbers. There's 1.2 million people right now in backlogged for employment-based green cards, and then kind of based on country, most of them from India, China, Mexico, and then 67,000 from the rest of the world. And I just have here S-386 was a Senate bill in last congressional cycle or congressional session that did not pass, which would eliminate these per country quotas. In Joe Biden's proposal to Congress yesterday, for a whole bunch of immigration overhauls, one of the things that he proposes is getting rid of the per country quotas and clearing all the backlogs right now, which would be amazing. So this is what the backlogs look like. So this is for January 2021, which we're in right now. And this is the visa bulletin that's on the Department of State website that they update every month. So just an example of if you are EB3 category, so you have a bachelor's degree and your company filed a perm for you, you're from China, and this is the country you're born in, and it says mainland born, but as of last year, they started including Hong Kong in China, FYI, which used to not be the case, which was great for people from Hong Kong. They would be considered all chargeability. But so if you look at the chart and go down EB3 and over to China, it has a date of December 15th, 2017. This is the date. If your priority date is December 15th, 2017 or earlier, you are eligible to file the third stage of your green card right now in January 2021. So that basically means that they're processing applications that were filed in December of 2017, that's a long time. And if you just kind of scan across the visa bulletin, India has the longest backlogs, unfortunately. If you're EB2, right now they're getting to cases that were filed October 8th, 2009. So that's 11 and a half years ago. It's a long time, and that's one of the things that the Biden administration wants to clear up. It's not fair to people from these countries, whereas if you look at the left column, all chargeability areas, that's basically any country that's not listed in a separate column. So if you're from the UK or France, C means current, which means you can file your I-140 and your adjustment of status application at the same time and probably get your green card in about a year. Whereas someone in the same exact job from China or India would have to wait. So it's an unfortunate situation, but if you're in an H-1B and you're in this long wait, you can extend your H-1B beyond that 6-year maximum period as long as you have an approved I-140. So you have to kind of get through part of the green card process, and then they say, okay, you're in line, you're waiting for the green card, you're from one of these countries that has long backlogs because of the government, it's no fault of your own, so we'll let you continue extending your H-1B. So unfortunately for Indian nationals, this often means extending your H-1B in 3-year increments for many, many years. But hopefully some new legislation might kind of get rid of that. No guarantee, but it's in the works. And then just some other green card categories that are not perm based, so meaning you don't have to do this recruitment and labor certification. The ones we talked about at the beginning: extraordinary ability alien, outstanding researcher, multinational manager, and national interest waiver. National interest waiver is a kind of narrow category, meaning your job will be in the national interest of the US for you to come here and work. So that's like pretty specific. Okay, now kind of updates. COVID-19 health-based travel restrictions. These are the countries that there are travel restrictions from to the US. Just the other day, Trump said he was lifting the Schengen, UK, Ireland, and Brazil travel bans, but the Biden administration is going to re-implement it because these are health-based travel restrictions. So it's just going to stay the same as it was. Other COVID-19 restrictions. So last March, most of the US consulates around the world closed or had limited service. Some of them are slowly reopening. It really depends on the consulate. Some of them processing regular applications, some of them only emergency, some not at all. So really be careful about traveling if you have an expired visa, because you might not be able to get back to the US anytime soon. Also March 2020, the Trump administration issued an executive order suspending certain immigrants. So this is green card consular applications That has been extended until March 31st. And that will probably be rescinded by the Biden administration, but it hasn't been yet. And same with June 2020, the H, L, and J non-immigrant suspension. So those you cannot apply for the H, L, or J visa at the US consulate abroad right now and come to the US, but you can apply from inside the US. And then something that's new, starting January 26th, all individuals entering the US, including US citizens and green card holders, must have a negative COVID test within 3 days of travel. So even if you have a valid visa and you go to your home country or somewhere, say you go to Mexico just to go on vacation, if you want to come back to the US, you're going to have to get a COVID test that's no more than 3 days prior to your travel back to the US. Biden administration day one executive orders. So that's today. Well, yesterday he issued the orders. Today's his first full day. So breaking news, the proposed legislation, which I mentioned a couple times, has a whole bunch of immigration benefits, including the path to citizenship for undocumented individuals, clearing those visa backlogs, eliminating per country quotas, and a whole bunch more stuff. There's a lot of stuff in there. All of it probably won't pass, but if they do get something passed, it might have a lot of that stuff in it. The Muslim travel ban was rescinded, so there were 13 countries, most of them predominantly Muslim countries. That was, if you remember, one of the first things that Trump did when he was in office. Now that's been rescinded, so that's great. He blocked deportation for Liberians living in the US. If you're from Liberia, this is great. Very narrow category. And then he also halted construction on the US-Mexico border wall. So no more border wall, or still a wall there, but no more building more wall. Okay, so I kind of rushed through the end just so we could get some questions in here. But thank you, and are there any?
Thank you so much, Lauren. I have a few questions here in the chat. Do you want me to read them out?
Sure.
So a question from an Australian student.
Okay.
In your experience, is it harder for creatives to gain the E3 versus other fields?
It depends on exactly, this is my lawyer answer, it depends. It depends on the field. For graphic artists and that type of field, and multimedia designers, which can also qualify as STEM depending on exactly what their code is. I haven't had too many issues. Sometimes I got some RFEs, requests for evidence on like graphic designer positions, but would eventually get approved. But it really depends on the category, and that there is a code. So for the LCA, they have SOC codes, and that's the broad occupation that you're in and what you qualify for. And if that position typically requires a bachelor's degree, so that's the key to the E3 or the H-1B, is that job typically requires a bachelor's degree. Some artist fields might not require, even though obviously there are many art schools and many degrees that you can get in artistic and creative fields. There's not always a bachelor's degree required for that field. But the more kind of technical a creative field gets, especially if it's like a tech creative field or multimedia type of thing, the better it gets. But I can always make an argument for any type of position to qualify. And the E3 is, especially if you apply at a consulate, is a little more lax than the H-1B. If you're filing with USCIS, they might do an RFE. If you apply for an E3 at a consulate, I remember I had a case, this is not creative, but I had a case, the guy was like a actuary or something, which would normally require like a math degree or economics, and he had a history degree, and it got approved at the consulate in Sydney. So there's a little more wiggle room, I think, with the E3.
Thank you.
Mhm.
Next question is about F1 status and getting married. So a student got married to U.S. citizens 2 months ago, and they sent their application to USCIS about a month ago. Do you know what are the next steps and how long would it take them to get a social security number, and what happens to their F1 status?
Yes. So if you're going through the green card process through a spouse, you would be filing the I-130 and the I-485 application, with, along with the application for a work card and a travel card. And that work and travel card are issued prior to when you get the green card. And those are right now are taking about 5 or 6 months. Like, it's taking a long time for EAD cards. It's like F1, OPT, EAD cards, they usually kind of fast track. But any other type of application, especially with a green card, right now are taking about 6 months. So you can stay in F1 status during that time and go to school, but you cannot work until you get the physical EAD card in the mail, which might be about 6 months. Maybe things will speed up with the Biden administration, I hope, but it's still the same people working at USCIS right now, so I'm not sure.
Yeah, and I just want to add is that we recommend that students stay in that F1 status until they get the physical approval notice. But if the student decides to end the F1 status after receiving the EAD card, they should consult with their lawyer who helped them with the process of applying.
Yes, definitely. That's a good point. I think for all visa types, one thing that I always recommend when individuals are applying for a green card through their employer, say their H-1B status is coming up for expiration, but they have their EAD card based on the green card application. They say, oh, I have this EAD card, I don't need the H-1B anymore. I always recommend keeping both and having the H-1B as like an underlying status in case something happens with the green card application. God forbid it gets denied, then you don't have your H-1B or your underlying status, and then you're out of luck and you don't have any work authorization. So back up, wait for those approvals, wait for the EAD card in your hand. Sometimes they get lost in the mail. Get it in your hands before you do anything.
Thank you. So Helen, you can actually ask Rachel, our senior advisor, the questions about STEM. She's the right person who does all our STEM OPT extensions. And I have another question for Lauren about, everyone is saying thank you for your great presentation. I really appreciate you and taking the time to present to our students. And the question is about from a PhD student who has a 21-year-long clean immigration record. He earned 2 MA degrees in the US and interested in waiving home residence requirement and applying for EB2, EB3, or EBA. Do you think it's possible?
And just to add that they're on a J1 currently.
Yeah. It depends on the reason that you are subject to that 2-year home residency requirement. So there are a couple reasons. It could be either the US government or your home country government funded your studies. It could be a skills list issue. Certain countries have a list of skills that they need in their country, and that's why they want you to come back for 2 years. Usually, if it's not a Fulbright scholar issue, you can always apply for the waiver. And it's a possibility. It just kind of depends on the country. Sometimes countries issue like no contest letters more willingly than other countries. But I would have to get more of the specific facts, but it's definitely possible to apply for a waiver depending on the situation.
Thank you. And I think we have time for one more question before we run out of time. The question is about OPT, so when a person applies for H-1B, so the person is on STEM OPT and is applying for H-1B lottery, can they change jobs between the time of application and October 1st? If they get picked in the lottery, then transfer their H-1B to the new company?
Yes, sometimes it's tricky. I've had this situation before. It depends how nice your current company that's applying for you wants to be to you. If you're leaving the company, they might not be too friendly in giving you any leniency in switching your H-1B. I would do it after, the best way to do that situation is wait until after October 1st. You're then in H-1B status, you're not in F1 anymore. And then in H-1B status, you're eligible to change employers, and the new employer would file an H-1B change of employer petition for you. If you change prior to October 1st, when you're in H-1B status, so say August 1st, you leave your current company and go to company B. Company A can withdraw that petition from USCIS and say, they're not working for us anymore, but we're not going to sponsor them. So they contact the government and say, we're withdrawing this H-1B. Then you have no H-1B. So if you're going to do that, wait until after October 1st, if that's a possibility. If not, then the second company would have to file an H-1B lottery registration for you as well, and you would have to get selected, but the odds of that are low.
Thank you so much again. We're so happy that Lauren was able to give this presentation to us today. It will be available as a recording on our Instagram, and also we will tag Lauren in it as well. So you can follow her on Instagram. You can see her email right there, lauren@laurenjolaw.com. And thank you again. It was wonderful to meet you in person. We wish everyone a great semester, and that's it.
Great. Thank you so much for having me. And anyone, feel free to reach out if you need, and if you have any questions, the email, social media. I'm pretty active on Instagram. You can send me a DM and I'll answer it pretty shortly.
Did my tag go through when I tagged you?
What's that?
When I tagged you on Instagram, did it go through?
Yep, I went through it. Yep, I saw that. Yeah, so have a great semester, everyone. I hope everyone's healthy and safe.
Thank you so much. Have a wonderful evening.
Thank you.
Thank you.
Bye-bye.
Bye.
Thank you, Lauren. Really appreciate it.
Bye.
Bye-bye.